happy Onam from me also to all of you. It is a reflection of the seriousness of the topic of today, that despite it being such an important festival for all of you, in fact, for all of us, we have such a large turnout. I am sorry if I may not leave you so happy by end of this session, but I definitely hope to throw a lot more clarity in terms of what the Arjun Panditrao's decision holds for us going forward than the decision itself probably has left us with. So without further ado, I'd like to jump right into the topic of today. It's really a strange journey. And in fact, my last article on electronic evidence is titled From Anwar to Arjun, A Tale of Two Ennies. I do like to get very creative with my titles, you know. So the whole construct behind my article was to capture the journey from the Supreme Court's judgment in Anwar versus Bashir to Arjun Panditrao. And this article was written before the final decision came in Arjun Panditrao's case. And the whole intent and purpose of the article was that it would help in guiding the outcome, at least that it may lend some value to a decision in the Arjun Panditrao case. Unfortunately, that has not been so. So before we jump into what Arjun Panditrao holds for us, a little bit of the background. We start, of course, with the Navjot Sandhu case, where the Supreme Court took a very practical view, taking into account probably two aspects. Primarily, so we are here, you know, in fact, when I start a session on electronic evidence, I always start off by saying electronic evidence is a very vast ocean, and section 65A and B are merely a few drops in that ocean. But today's session is totally focused only on these two provisions, section 65A and 65B of the Indian Evidence Act. And Arjun Panditrao's decision has kind of like expanded the scope and the complexities that this provision already came with a lot more than was warranted. So just stepping back again to the background, you know, we are lawyers. We like a preamble more before we come to the substantive portion. So here is the preamble to Arjun Panditrao. In Navjot Sandhu, the Supreme Court took into account section 65A and the use of the word may there to say that it, you know, the conditions in 65B may be complied with if you wish to rely on electronic evidence. The second pointer that you get is in 65B4, it also starts off with if a person desires to rely on. So therefore, these two read together were taken as 65B4, the certificate to be issued under 65B4 being only discretionary and not mandatory. And the Supreme Court held that you could still go under general provisions of secondary evidence under 63 and 65 to rely on secondary copies of electronic evidence. And then came Anwar, nearly 10 years later, and it did not do a prospective overruling as the Supreme Court pointed out in Sonu versus State of Haryana, but overturned Navjot Sandhu. What it did was, in effect, it just captured that 65A and B were a code in itself when it came to proving of electronic evidence, and that therefore, whatever the conditions that were laid down in 65A and B had to be complied with if you had to rely on electronic records. These are the points that were clarified in Anwar versus Bashir. The first and the most important issue, that if you are relying on the original of an electronic record, then you do not have to comply with section 65A and B. So this was sacrosanct. It remains the same today, except for an uncalled for clarification that Arjun Panditrao comes up with, which I will be covering later. So the first thing which you can take as a given when you're going forward as a practical tip is, if you're relying on the original electronic record, you do not need a certificate. It is only when you're relying on a copy of an electronic record that you have to comply with the conditions set out in 65B. What are the conditions? Again, is the second part, which is dealt with by Anwar versus Bashir. It went on to say that if you are relying on secondary evidence, which is copy, which could be a printout or a copy made on an electronic medium also, then it held that 65A and B are a code in itself, and therefore you have to comply with the conditions in 65B. The first condition that it pointed out was that you have to give the certificate under 65B4. 2, and here is where it got a little complicated with Anwar. What should the certificate contain? Anwar versus Bashir held that there are 3 criteria which are set out in 65B4. The first is to identify the device and the manner in which the record is produced. The second is to identify the process in which a document is produced to show that it is a computer output. And the third was to comply with the conditions set out in 65B2. And in 65B2, 4 conditions are set out. Primarily to show that a document is a computer output, that it has been created in the ordinary course of business, that there has not been any alteration or modification, no disruption or damage to the computer resource such as to affect the integrity or authenticity of the document. And to show that the document is, here if the part 4 actually is a reproduction of part 2. If you look at it, 65B2B and D are effectively similar, if not the same. And that is how 65B2 is structured. Now, when Anwar was deciding on the conditions, despite the fact that 65B4 said that if a person desires to rely on a copy of an electronic record during evidence, they shall produce a certificate setting out any of the following. So you only had to prove what was the device used in the manner in which it was created, or the process to show that it is a computer output, or comply with the 4 conditions under 65B2. And in 65B2 also, if you look at the construction, A, B, and C do not have a conjunction. Only at C you have the conjunction and then D comes in. However, Anwar interpreted it to mean that you have to comply with all 4 conditions. So effectively what Anwar did was, it said you have to comply with all 3 conditions in 65B4 and not any of them. So that meant you had to comply with a total of 6 conditions in your certificate if you have to rely on a copy of an electronic record. So in doing that, it also clarified that the person who is giving the certificate has to only prove to the best of their knowledge or belief. So therefore, you did not have to have a very high threshold of knowledge the way you would have to do with even an original of a document to prove its contents. But here it was only a threshold of knowledge or belief. Now, when you look at why such a low threshold was set out, was that what was the purpose behind 65A and B? If you look at the last article which I've written in terms of from Arjun to Anwar, I start off with this quote from Tata Power Company, the Supreme Court's judgment on a statute must be construed having regard to parliamentary intent. For the said purpose, it is open to a court not only to take into consideration the history of the legislation, including the mischief sought to be remedied, but also the objects and purpose it seeks to achieve. Now, what was the object and purpose that Section 65A and B sought to achieve? It would be really absurd to assume that the legislature decided that lawyers and litigants cannot have it easy when they are relying on electronic evidence. They obviously did not believe that we have to be punished because we are relying on electronic evidence, and therefore things have to be made very complicated. Their assumption when they drafted 65A and B was that they were actually making it easier to rely on electronic evidence than you would have to do under 62, 63 or 65. 62 and 61 remain as is because 62, 65A and B only deal with the secondary copies of electronic records. So in doing this, when I say that their intent was good, that they thought they were making it easier, but the execution was bad, the reason I'm saying it is if you look at all the preconditions that you have to follow when you have to rely on 63 or 65, including a notice to produce, including to show the reproduction, the mechanical reproduction, because otherwise just look at 63. Why did we need a 65A or B? 63 and 65, when you look at the sub-provisions, you already have provisions which covered the production of secondary evidence of electronic records. The definition of the word document did not have to be modified merely because we are now relying on electronic records. Such a beautifully dynamic provision encompasses everything from a rock edict to an electronic record today. That is true dynamism and excellent draftsmanship, if you ask me. So it did not need modification. It certainly did not need the confusion that Arjun Panditrao has brought into the picture. Now, when Anwar versus Bashir was looking at it, curiously, that case dealt with an election petition. Arjun Panditrao has a similar background of dealing with an election petition, and I will come to what it brought up before, after completing the kind of journey that happened. After Anwar, what happened? We had a situation where it very clearly laid down that you have to give the certificate. It also said that it is enough if you give the certificate to the best of your knowledge or belief. And it also clarified that you did not have to give the certificate if you're relying on an original document. Now, the problem happened, and I saw before I started a question that was raised in terms of what happens with third-party documents. Now, you have various kinds of electronic records. It could be an electronic record that you have created in your own computer, like a Word document or a presentation also, whatnot. It could be an email which you have created and shared with somebody. So there are two recipients there. A person who has formulated the email and sent it, the author of the email will be able to speak about it. So can the recipient, typical to what we face when we are relying on a letter or communication, official communication. So you then have the next step, which is like a social media post or an online post. There you have a situation where there is an author, but there is also a platform which is the service provider, which has the content on its platform. Now, there are two parties, but the second party is not accessible for you to either seek clarification in terms of the authenticity and integrity or to get a certificate from. The person who is the author of a social media post may be the adversary. So therefore, that person is not going to give you a certificate. A similar situation, as another question was raised also in terms of the distinction between civil and criminal cases. The primary fallacy in terms of the drafting of Section 65B lies here. As has been pointed out in Arjun Panditrao's case, Section 65B predominantly draws from a civil provision under UK laws. It did not draw as much from the criminal provision, but it drew from the civil provision, forgetting completely that the Indian Evidence Act applies pari passu for both civil and criminal cases. So when a proviso is added saying that a person in charge of a computer or an administrator can give the certificate with respect to the production of the document or the activity. So the certificate can be on two counts. It doesn't have to be only with respect to the contents of the document. It can be on both counts. So when it talked about that, it completely forgot that in a criminal matter, you're not going to be able to call upon the accused to give a certificate. So this is where there were already complexities in terms of who should give the certificate, when should the certificate be given, how should the certificate be given, does it have to be in an affidavit format or in the format of just a standard certificate? And what should the certificate contain? Now, when you talk about all these aspects, what happens in terms of the Anwar case was it did not answer these aspects. It gave a very peremptory decision and moved on. Even when you look at the Anwar judgment, you will notice that there were not very detailed discussions in terms of the various aspects of Section 65B and how each of them has an interplay. Each aspect of, what is the relevance of each word or phrase in this very long provision have all not been analyzed at depth. The court merely went into 2 points, which is one, special overrules general, and said these two special provisions therefore overrule the general provisions. And two, it talked about what does the special provision mean in terms of having to give the certificate. Just summing up on Anwar before we move ahead. One, yes, certificate mandatory. Two, that it has to cover all 6 conditions. 2 of the conditions under Section 65B4 A and B, and the 4 conditions under Section 65B2. And then it moved on to state that it can be given by a person to the best of their knowledge or belief, and left it at that. And of course, that an original does not need the certificate. Now, when Sonu versus State of Haryana took up this issue and said that they could have done prospective overruling of Navjot Sandhu, and unfortunately they didn't mention that, they tried to protect cases which would have been pursued without the certificate for so many years, nearly a decade. And their way of doing it was to say that the non-submission of the certificate is a curable defect, and therefore you can give the certificate at any point of time. And this followed to a large extent 3 High Court judgments. One was in Kundan Shaw's, and then Paras Jain's, and also K. Ramajayam from Madras High Court. All 3 of these were very relevant in terms of helping on all these other queries that I posed in terms of when should the certificate be given, how should it be given, what should it contain, etc. Now, one of the aspects that Ramajayam's judgment also covered, of course, all of them talked about how it is a curable defect and it can be given at any point of time. It does not have to be only at the stage of charge sheet. It can be given later, even if it has not been given at the time of submission of the document, electronic record in evidence, it can be cured. Now, this aspect was also affirmed by 2 further judgments from the Supreme Court itself, the last being on Ravinder Desai's case. But what happened thereafter, we'll again come to in that. But before we move forward, Sonu versus State of Haryana said it's a curable defect, which Arjun Panditrao is not really upset except for certain aspects. And that's where that one question somebody has raised about where do we stand today in terms of when should this certificate be given in a civil and criminal case becomes very relevant. Now, there are a lot of problems happen. I have given you examples of 3 or 4 different kinds of electronic records. Now, let's take it even further. So I spoke about social media posts, which is done by a human and available with a service provider, but there may not necessarily be a recipient. Sometimes even a post could have a recipient. Technically, one could say that if it is a reply to somebody's post, just like how communications are exchanged by letters, where somebody says something and a reply is sent, we could draw a similar comparison in terms of even a social media post. There are also computer records which are automatically created. A classic example I like to rely on is a Google Earth picture, right? So this is not really done through human intervention, but it is actually an automated process. So there are 2 provisions in Section 65B which are barely read, which is Section 65B3 and Section 65B5. So the relevance of these 2 also I'll cover after I complete in terms of Arjun Panditrao, but in case I miss out, very, very briefly, let me tell you. Even when it comes to the original in a computer resource, it is actually very difficult to pinpoint what is an original. Now, for instance, we have a document that is created on an email platform. Now, what you are seeing on your computer is actually an access process given to the server which is hosting your email ID. So do you assume that the screen that is visible to you on your computer is the original, or only the server that is hosted by the service provider? To make it even simpler, if you're using a Gmail ID and you have nappinai@gmail.com, and I'm sending you an email confirming I'm most happy to attend this lecture and to deliver this session for all of you, and you receive this and you're relying on this email. When I'm sending this email, I may be using my computer's mailbox, right? Which is the equivalent of an Outlook Express. Or I may be accessing this mailbox on a browser. So when I'm accessing it from my computer, this mail resides in my computer as well as the Gmail server. When I'm accessing it from a browser, however, it is only residing on the server. So at one point of time, therefore, you already have 2 originals. In similar fashion, even when you create a Word document in your computer, you at one point of time actually have 2 originals. You have a temporary file which is automatically saving whatever you're doing. That is what helps you when your computer crashes and you actually have a recovery that comes from your temporary file. And then you have the saved file on your folder, which is on the hard disk. So even when we are creating something, we have multiple originals. Thereafter, from the time when this document is created to the time you're relying on it before a court, there are so many other copies actually being created, but each of them technically are an original in a computer resource. Right? Because let's just take some examples. Now, predominantly, I have dealt with a lot of cases, cybercrime or cyber law cases. Okay, let's take cybercrime cases because it's actually a lot more complex in terms of electronic evidence. So in cybercrime cases, the maximum kind of cases I've dealt with are pertaining to economic offenses. So data theft particularly. And many, many instances where the employees themselves have committed data theft. It will invariably happen just before they leave the company or during their notice period, etc. Now you have a situation, I'm going to just give you one example to make it easier to understand the process. Now let's take a case of an employee who is serving out their notice period, and during that notice period, they decide to take away certain source codes that belong to the company. Now, the source codes are hosted at folder A, but they are then copied on to folder B, which is of the employees folder, and smaller files of the same are created. And then each of these files are sent by email to the personal email ID of the employee. And that is the manner in which the data theft happens. So in data theft on electronic trails, you don't have physically, have physical movement. You have a trail which moves from one electronic medium to the other. Now you have the source codes in the computer. You have the proof of the saving or copying of those into the folder of the employee. So you have the files in the folder of the employee, and then you have files in that same folder which are split into smaller portions, and then you have the proof of the emails having been sent. Because from a computer, even if you use a browser to send mails to yourself, it can be tracked. Many people think that only if it is in the outbox or in the mailbox, it can be tracked. That is incorrect. Even the history in terms of access to a server and all the mails shared and the attachments to it can also be tracked using a software. So you have that trail which shows that it has been sent. And then you also have this electronic record proof from the mailbox now of the accused, because at this stage, the employee who has been found out to have committed data theft has become the accused. Now you also have the proof in their mailbox that indeed these files were sent to their personal account. Now, when you have to prove this case, you have to rely on each and every chain in this link of evidence. Because otherwise, if you merely show that you are the owner of the source code because it is there on your folder, that is not enough. Because all you're proving then is that you're the owner. Then you come to the second stage where you're proving that your employee, whilst in your employment, because he or she is just serving out a notice period, right, has copied it to their folder, doesn't prove anything because they were entitled to at that point of time. Splitting it up and having it in their folder again may show the mens rea, but doesn't really prove anything further, right? The mens rea with the actus reus happens when those split documents are sent to their personal mail ID. Now, when you are doing that link between the preparatory process and the execution process, the actual attempt and completion of the crime, that is the link you have to prove. And now you will understand when I say about third-party documents. Now here is a situation where the primary link to prove the complicity of the accused lies in the control of the accused. At best, the only other entity which has access to it and can speak about it is the Gmail server. So you have a Gmail server which has this mail ID. You may be able to show from your own records of the internet history to show that a browser was used for transferring it. But the strongest piece of evidence is there in the mailbox. And the accused cannot and will not give the certificate. Where does it leave you? Now, Shafi Mohammed took into account these kind of issues and said many cases exist where the documents may be in the custody of the deponent. It could be either as the author or the recipient, and therefore we are fully in agreement that the certificate is mandated. We are fully with Anwar versus Bashir in saying the certificate is necessary. It is a code in itself, etc., but only for documents like this. But when it is a third-party document, then this certificate cannot be held to be necessary or mandated, because it is not possible for a person to give a certificate even to the best of their knowledge and belief with respect to a document which is lying in a third-party server. So how can we give a certificate or say that a certificate is mandatory in such circumstances? And therefore, Shafi Mohammed said that where it is a document in your custody, then you give the certificate. In other cases, the certificate may not be necessary. And this is where many a fallacy came up with respect to Shafi Mohammed also. Firstly, it said that the decision on whether the certificate is needed or not is left purely with the discretion of the trial court. The reason all this becomes important is when you see how the convoluted process works in Arjun Panditrao's case, where they negate all of these and overrule it and literally come back to square one in the explanation and what they allow thereafter. So what they finally hold or allow, if you compare that with Shafi Mohammed, you probably just had the simpler solution. It would have been a lot easier if it had been analyzed further instead of just stopping with the obvious problem with Shafi Mohammed, which is that it was a 2-judge bench, which was trying to clarify a decision of a 3-judge bench. And if that had been set aside and gone, if only the principles and the issues that were pointed out in Shafi Mohammed had gone into, we may have got a decision which would have been a lot clearer. Unfortunately, that was not so. So it's important to know, therefore, what is the mischief that Shafi Mohammed was trying to sort out, and what is it that was reversed, and where do we stand today? So Shafi Mohammed said in those cases where it is a document which is in the custody of a third party, the court has to decide whether it can be waived or not. What can be waived? The certificate can be waived or not for the copies of such documents. The first level of fallacy, whether it is with Anwar or with Shafi Mohammed, and definitely with Arjun Panditrao, is the fact that very, very peremptorily, because Shafi Mohammed does not even go into it, but Arjun Panditrao's as well as Anwar versus Bashir treat this aspect in a very peremptory manner without understanding the importance or implication, as I've said in my article, of the 2 NEs. And why is it important? And this is why I went into a little bit of length on the various kinds of electronic records. Now, when you look at 65B4, I would in fact request you all to open 65B4 to have a look at it. I'm also going to try and take it up. You will see the reason why the NE is important when it comes to third-party documents. Now, when you look at 65B2 first, you will realize that every single condition there is very easy for you to comply with, provided the document is in your custody. So let's go to 65B2 first, because then it will explain 65B4 a lot better. As I already told you, one and foremost, the word computer output that is used in 65B2 is clearly defined in 65B1 as a copy of a document or information in an electronic form or electronic record. So computer output here is not what is, our general awareness of what is a computer output would mean what a computer has generated. Whereas that is not the definition given in the profession. It is the copy of information that is in contained in an electronic record. So when you take a computer output, you need to prove that it was produced by a computer in the regular process of storing or processing information in activities that are regularly carried out over a period where the person, by a person having lawful control. This is why I requested you all to actually take the provision in your hand. Because if we are to really implement Anwar versus Bashir as well as Arjun Panditrao, most of the offenses under the IT Act now can no longer be offenses, cannot even be proven. You might as well just take them out of the legislations. In fact, in one case, I'm digressing here to give you a practical example. Now, this was a case of an ATM tampering. Now, when you tamper with an electronic record, that is an offense under Section 43 of the IT Act, read with 66 of the IT Act. Now, what 43 says is, any person who gains unauthorized access to a computer resource without the consent of the owner, and now you know why I paused after 65(2)(a), 65(b)(2)(a), right? So many subclauses, because it talks about computer output by a person having lawful control over the computer in regular activities carried out by them. Hacking or an unauthorized access, which is what I've talked about first, which is effectively hacking, gaining access through illegal means, right? It could be technology enabled or it could just be exceeding access. But that in itself is an offense. That in itself is by somebody who is not in control of a computer. And when it is a case like this, and you have to prove the very fact which you are otherwise supposed to aver in your certificate, saying that there has been no disruption or intrusion which has damaged or tampered or modified the document under 65(b)(2). How is it going to sustain your case, right? And where you're talking about access by a person who is not in lawful control, because the electronic record that you have to rely on, and hacking will necessarily need reliance on an electronic record, right? The very electronic record is a modification by somebody who is not in control of the computer. So in this case, which was which had a very curious turn. Now the ATM was hacked. There was a problem. Now, one of the customers who had visited, this is a very small kind of a case, like, you know, in the Cosmos Bank case. In Cosmos Bank, the SWIFT was breached, and therefore people who would go to the ATM were able to withdraw money which was not there in their account. Now, in a similar situation here, a person who did not have this money, he withdraws, let's say, 5,000 rupees first. He again withdraws 5,000, totally 3 times, but he only had 5,000 rupees in his account. So 2 out of the 3 withdrawals were wrong. The customer knew that this was not money which was in his account. Now, when the bank was trying to prove the customer's complicity in a crime or in a violation, this was a civil case, the court holds that you can't rely on this electronic record because your own averment is that the ATM was tampered with. And you cannot then give a certificate saying that there has been no tampering with the computer resource such as to affect the integrity of the document, right? Just to move forward in 65(b)(2). What does 2B talk about? It talks about, during the said period, an electronic record or of the kind from which the information is so derived was regularly fed into the computer in the ordinary course of activities. So there are 2 elements here, which is that it is the information that is regularly fed into the computer in the ordinary course of activities. And it also talks about either the information that is fed or the information which is derived from it. So please jump forward to D, where it talks about information contained in an electronic record reproduces or is derived from such information fed into the computer in the ordinary course of said activities. Nothing really different from B. B is more comprehensive rather than D, that's all. C, and this is what I was talking about in this particular case. Throughout the material part of the set period, the computer was operating properly without any disruption or damage that affects the electronic record or the accuracy of its contents. Now, I'm going to take you all back a little bit. This is a little bit like a Mani Ratnam movie. I'm just moving you back and forth. I hope all of this is also keeping your attentions in this, in this very, very interesting analysis. Because, the very complexity of the provision also lends itself to its analysis. You go back to 165B1. Again, I'm coming back to the quote which I took from Tata Power on what was the mischief, what was the purpose of this provision, what was the mischief it was supposed to protect against. It is actually very simple. We are all veterans of many wars, in trial courts. We are aware that there are two fundamentals when it comes to evidence, which is the authenticity and integrity of a document. Why is an original accepted under 62? Because with the original, you're able to show that the document has not been tampered with or modified. That is why when you produce an original with writing on it, it is still considered an original which is not tampered or modified, because you would still explain what was the modification. As lawyers, every day we do this. Whenever we receive something, immediately we put a stamp on it with our name, the person who has received it, the date and time of receipt of the document. Does it then dilute or take away from that the integrity of the document? No. We can still rely on the document received as an original by explaining the mode and manner in which we received it and how we put that stamp. In similar fashion, in an electronic record, what 65B intended was that you will be able to show that this is a document, you will show the integrity of the contents. So when it uses the word as evidence of any contents of the original or of any fact stated therein, as has been interpreted in earlier cases where similar phrases were used, it doesn't mean that what is mentioned in the electronic record is true. It only means that the electronic record is not tampered with. It is authentic and that the integrity of the document is maintained and nothing has been changed. Once you read 1 along with 2, you will have to necessarily give a harmonious interpretation to say that when the legislator said that you will show that this is in the ordinary course of business, being done by the owner of the computer, or of an electronic record regularly fed into a computer, or that a disruption or damage has not affected it is only with respect to the document that is being produced. Meaning, once the document is tampered with. You have had a case of hacking. I told you about the data theft. So there has been modification to the document. But what are you producing before the court? You're producing secondary evidence of that original, which is of the tampered document. So what is the original is the tampered document, not just the document preceding it. So once you take the tampered document as the original, then you will realize everything else becomes clearer, because the mischief that was sought to be clarified was the integrity of that original. So all you're saying is, this is the tampering that employee, and the timestamp and the metadata of this file will show that on and after the date when the employee modified this document, the company has not changed anything. The company is not trying to file a false case against the employee by modifying or tampering with this, the documents and then producing a copy before this court. Now, that is all the certificate is supposed to prove. If you do not understand this purpose and the mischief part, then you're bound to be misled when you read the rest of it. Now, when you look at the other provisions in this context, you will realize why I told you that the legislators did not mean to punish us. They were thinking in their, probably in their mind that they were actually helping us. Because what did they say? You just say to the best of your knowledge or belief that A, identify the electronic record containing the statement and describe the manner in which it was produced. So when I told you about the Google Earth thing, you just had to explain how Google Earth works and how this document was created automatically and all that through a satellite image, etc. And you only had to give a certificate saying to the best of my knowledge or belief. I will also come to this aspect in Arjun Panditrao and how they really failed to go the last mile in helping us rely better on electronic evidence. And that was actually the purpose and crux of the reference to the larger bench of the Supreme Court itself, which unfortunately has been missed. So the first of identifying an electronic record and describing how it was produced could be used for a document which you have created or shared. It can be used for a document which has been uploaded online on a social media platform or even on an email, etc. And it could have been used also for automated purposes. Now, this is where I'm going to again pause and do another Mani Ratnam on you all and go to subclauses 3 and 5. The intent and purpose of 3 and 5 is 3 helps you to understand why everything that is in the computer resource where you are using to create a document, etc., or a series of computer resources where the document's chain of custody can be traced, all form part of one document. So the concept that every single document in the chain can be treated as an original comes from subclause 3. Now, subclause 5 helps you in understanding that the document, electronic record, could be by a human or with or without human intervention. So the sanctity to the electronic record, irrespective of who created it, irrespective of how it was created, your ability or your right to rely on it comes from subclause 5. And therefore, these two are so important and sadly ignored. And it would have been most relevant for the Supreme Court to go into these aspects and not just take 65B4 and 2 in isolation. Everything had to be read together to get a cogency on the purpose behind the provision and the mischief it was trying to resolve. Moving forward to 65B4. What does B tell you? You just have to give the particulars of the device involved in the production of the electronic record and show that the electronic record was produced by a computer. So you did not have to worry about who has produced or who has produced also. You just had to show what had produced it. It may have been produced by an individual or without human intervention. It did not matter. Now, A and B are so wide in their application that it enabled you as a recipient of a copy also to give a certificate to the best of your knowledge. Before going to C, I'm going to just pause again and take you all to the proviso. Now, the proviso, when it talks about and purporting to be signed by a person occupying a responsible official position in relation to the operation of the relevant device or the management of the relevant activities, whichever is appropriate. Now, in Anwar's case, this aspect was not gone into at all. In Arjun Panditrao's case, the court actually notes this, saying that this document, the certificate, can be given by a person in a responsible official position operating the device or managing the activities. It could have definitely given better help to us by explaining what is the meaning of relevant device or relevant activities and what is the meaning of responsible official position. However, considering the manner in which they have clarified a few other things, maybe we are better off that they didn't clarify this and they've left it open for the posterity, right? So, nevertheless, here is the situation where the most important thing which would have helped, one, in understanding why it is any on top, and two, more importantly, even if it is all, how it can still be overcome, because you can either be a person in charge of the device which created all this, okay? Or you're in charge of the management of the relevant activities. Now, the word relevant activities comes in multiple places, and that's why I wanted to pause before taking you all to 65B4C. 65B4C is nothing but a reaffirmation that you can give the certificate on any of the matters set out in 65B2. Now, this is the second any that I have mentioned in my article. When you look at 65B4C and 65B42, you could say that there is an inconsistency here. Because 65B4C says you only have to give the certificate on any of the provisions under 65B2. However, 65B2 starts off by saying that the conditions referred to in 1 shall be the following. Okay? And the conditions referred to in 1 is even more confusing. The non-obstante, which has been reiterated ad nauseum by the Supreme Court, goes on to also say, notwithstanding anything contained, any information in etc., shall be deemed to be also a document. The also unfortunately seems to have been missed. Also a document if the conditions mentioned in this section are satisfied. So reading 1 and the first part of 2 together, it may have given the impression that it is all of the conditions. But when you read 65B4, which is very explicit, which says any of the following, and 65B4C, which also says any of the conditions under 65B2, and most importantly, when you go further down to 65B2 and you look at A, B, and C, none of these, as I pointed out earlier, has any conjunction. Therefore, we could easily interpret it as or instead of what it has been interpreted as, which is and. According to me, and this is what I have explained in all the articles I have written on this particular subject, and also in the book which is covered in the chapter on electronic evidence, is that A, B, and C could be construed as or, and only D can be construed as and. Meaning A and D have to be proven, or B and D, or C and D. The minute you take it that way, then you have technically 5 conditions only. And each of these 5 conditions are or, and you have a 6th condition, which is an and, only for 3 of those conditions. I know it can sound very confusing, but when you apply this example which I gave you of this data theft case, I could have proven it by just proving how it was, how this document was created, the device, what is this electronic record that this employee created and how it was created. I'm talking about that email which was sent. I could have proven it also by just relying on the device used to send it, show the internet history, and then compare it with the seizure done from the employee's computer and prove it still to the best of my knowledge and belief. And even if I had taken recourse to one of the conditions under 65B2, I could have shown that the documents that I am relying on are indeed a computer output. It was in the lawful custody of the employee, because I don't have to necessarily prove that it was in my lawful custody for me to give the certificate. Since I'm only giving it to the best of my knowledge or belief, I only had to say, this internet history is from my computer resources, and I know to the best of my knowledge and belief that it has not been tampered with. Taking that link further, through this internet browser, I am able to show that these documents which belong to me have been stolen by sending an email to the personal ID of the accused, and the document seized from the accused, I'm identifying my proprietary data in that email, and to my knowledge and belief, this is a document which is a computer output produced in the ordinary course, and that this is the only person who had lawful control of the computer, who? The accused. Now you can see how it's becoming much simpler, right? So it is not so hard. It is complicated, but it is not impossible. It's like the Dawn, says nothing is impossible. But we move forward now from Shafi Mohammed to Arjun Panditrao's case. What did Arjun Panditrao do? Now, Arjun Panditrao's case said that Anwar versus Bashir was a 3-judge bench. Shafi Mohammed was a 2-judge bench. And of course, you also had a Tommaso Bruno's case in between, which is also by a 3-judge bench. And we need certainty in terms of reliance on electronic records. And they also record why that certainty is needed. Because today you cannot have one legal proceeding where an electronic record will not be involved. Given this circumstance, you needed clarity in terms of how and in what manner should you prove and rely on an electronic record. And it was for this purpose that Arjun Panditrao sent it as a reference for a larger bench to decide on it. The first error happened when a 3-judge bench was formulated to decide on this issue, because the assumption then is that the reference was only with respect to Shafi Mohammed. But that was not the case. Though the court refers to both of these judgments, the real crux of the reference was the need for certainty with respect to electronic records. Considering that Anwar versus Bashir was not such an elaborate discussion or an analysis of the provision, considering that subsequent judgments of the Supreme Court itself had pointed out various issues and concerns with respect to the Anwar judgment, it would have been appropriate that the court had formulated a larger bench. And finally, considering that Tommaso Bruno was also a 3-judge bench, it was mandatory that a larger bench had been constituted to decide on the interpretation of section 65A and B. It is surprising that this was not taken up as a preliminary issue and had not been decided, but just decided as a par for the course in Arjun Panditrao's case by a 3-judge bench. It is even more surprising that Tommaso Bruno, which is also a 3-judge bench case, is taken up and decided by yet another 3-judge bench case without realizing that a reference to a larger bench was needed. According to me, without even going into the issue of Tommaso Bruno, just on the basis that Anwar versus Bashir was not decided with elaborate analysis on section 65B, and considering the background with respect to Navjot Sandhu, whether the court decided on reopening Navjot Sandhu or not, it had to be sent to a larger bench. It was not done. Let me sum up very quickly what Arjun Panditrao said. One, it says, and this is where it is very worrisome, and that's why I pointed out the definition of the word document. It says that the definition of document does not encompass electronic records. It is completely wrong in terms of a finding, because if you look at 65A and B also, the reference there is to also deem to be an electronic record, and that also the deeming fiction is not with respect to an electronic record, but with respect to copies of an electronic record. So nowhere does the provision say that an electronic record is not a document. It merely uses the word, in fact, I wouldn't have interpreted that to say that it is also deemed to be an original. What they intended was to say that it will stand on par with an original. Their intention was not to say that electronic records are not documents, because the definition of the word document very clearly covers it. The explanation or the addition, the phrase of deemed also to be a document, the word also there clearly indicates that the copy also is a document on par with the original, and that seems to be the intent of the legislature, which has been missed out. Two, very peremptorily, again, without going into any of the issues which I just pointed out in terms of 65B4 and 65B2, very peremptorily, the Supreme Court reiterates that section 65B2 is cumulative, meaning you have to prove all 4 parameters in your certificate. It again also very peremptorily says, without any analysis or depth, that 65B4A to C, that is 65B4, is cumulative. So you have to prove all 3 parameters in the certificate. It then goes on to say that or if the original is produced, then a certificate is not needed. Apart from Anwar versus Bashir, the Supreme Court also relies on Vikram Singh's case on that. It then goes on to hold Tommaso Bruno as per incurium, because, and here is the curious part of it, Tommaso Bruno comes immediately after Anwar versus Bashir. Justice Kurian Joseph has given the leading judgment in Anwar versus Bashir. Though in Tommaso Bruno, the judgment was pronounced by R. Bhanumati, it is a concurrent judgment, and the bench comprises Justice Kurian Joseph. If I may share a personal anecdote here, I must say this with folded hands, I have not come across a better person, a better individual than Justice Kurian Joseph. He was still a sitting judge of the Supreme Court, and I'm just a practitioner before the Supreme Court now. And as was mentioned in my introduction, I hail from Chennai, and I just believe in stating my mind as it is. I was giving a session before the National Judicial Academy, and we were discussing thereafter about the interpretation of Anwar versus Bashir. And I used the statement that, with due respect to the Supreme Court, the decision in Anwar versus Bashir is fallacious. So Justice Kurian Joseph interrupted me and he said, "Madam, I wrote the judgment in Anwar versus Bashir." So I just turned to him and smiled and said, "My lord, then with due respect to you, the judgment is fallacious." And then he just smiled at that. He did not take affront, he just smiled at that and he said, "Justify yourself." And then I explained whatever I have already shared with you all now. And that gentleman was so fine. He then convinced me that just covering all this in my book was not enough. If I want to create better understanding of this, to ensure that these errors are corrected, then I must write an article. So the SEC article citation which I shared with you all was at the instance of Justice Kurian Joseph. He insisted that I must write this article, and I wrote this at his behest. So I was really hoping that with this article and with the further writings that I've done, with the last being of from Anwar to Arjun, that there would be a decision that would come out with a lot more clarity. I really wish that Justice Kurian Joseph had had the opportunity to review his own judgment to give a more clear elucidation on this provision, but that was not to be, and we now have Arjun Panditrao. The fallacy that Arjun Panditrao does is, on one place, it holds Tommaso Bruno to be per incurium. One could say that it may not necessarily be wrong in terms of what the court has held, but it also goes on to say it overrules Tommaso Bruno. A 3-judge bench cannot overrule another 3-judge bench's decision. It then goes on to overrule Shafi Mohammed, saying that what Shafi Mohammed had said about clarifying. And here is where the issue is. It says that the clarification given by Shafi Mohammed is wrong. And therefore, it cannot be that, where in certain cases the certificate is necessary, but in certain cases where the document is not in your custody, certificate is not necessary. Certificate is mandatory for everything. And it moves on from there to say Shafi Mohammed is overruled. Finally, it also overrules that portion of Ramajam's judgment by the Madras High Court, where they said that aliunde, even evidence given with respect to the document can be treated as a certificate, and therefore it can be accepted on record. Simply put, what was the background? Now, as in this case, if there is only oral evidence given, as in Arjun Panditrao's case, in Arjun Panditrao's case, oral evidence is given with respect to the electronic records that have been given. The respondent in the SLP, their claim was that they tried time and again to ask for the certificate, but the persons who had to issue the certificate willfully failed to give the certificate. So they were relying on the oral evidence given with respect to it, and also relying on Ramajam to say that therefore it has to be held to be valid. But the Supreme Court held in Arjun Panditrao that it is incorrect to say that if it is only in evidence that it is proven, it is not sufficient as a certificate. The certificate has to be in writing. Therefore, here again, you have clarity to one of the questions that was raised, that an evidence cannot be the ground for or cannot be substituted for the certificate. The certificate has to be given separately. It also then very peremptorily, as I already pointed out, very peremptorily holds that the certificate, however, has to be given only by a person who is holding a responsible official position to the device or the activities. It does not clarify what it means by device or activity. Here, if I can pause and give you some clarity, I will attempt at least to do that. As I pointed out with the example which I gave you, it is, there are two things that happen here. One is a device is used to create an electronic record, and two, there is an activity that is involved before you produce a copy of the electronic record before the court. So my interpretation of that part is that the person who was in charge of the device or an administrator of it or the owner can give the certificate with respect to what are the contents that are there in the device, right? And therefore the copy is made because the device cannot be carried to court, or the person who performs the activities involved in formulating or creating the copy can also give the certificate. If this interpretation is not given, then third-party documents cannot be relied on. Now, this could have been a very simple way of overcoming this aspect with respect to third-party documents. Unfortunately, this is not the way the Supreme Court moves forward. Now, this is where we come to the next stage in Arjun Panditrao's decision, where a very curious situation happens. Firstly, the court affirms again that 65A and B are a code in itself. But it takes it a step forward to make it seem like 65A and B not only override 63 and 65, which is what Anwar pronounced, but it also overrides 62 to 65. Now, the difficulty that happens with that is, once you have decided that you have to give this certificate, etc., only when a copy is produced, once you read 65B, which clearly says that this is for the procedure to be followed when you are relying on a computer output, and computer output is interpreted to mean a copy of an information in a computer, in an electronic record, then there was no question of holding that 65A and B will override 62. And in support of that, this three-judge bench clarifies Anwar's three-judge bench to say the portion where they refer to relying on section 62, say that an original, however, does not need a certificate, that portion saying relying on 62 is set aside and saying the rest of it holds good. How? If you remove 62, then what is the legislative support to state that an original does not need a certificate? But before we go into that question, the first question is, why do you even need to do this? Because you can still sustain the argument that 65A and B are a code in themselves for the purpose of secondary evidence. Nowhere is it necessary to say that it is a code in itself for electronic records itself, because that is not what it says. So based on this fallacious finding is where you have the earlier one, which I pointed out to you, which is that it holds that a document doesn't comprise electronic records. It goes on to say that even with respect to original being allowed, it is not because of 62, and then goes on to hold that 60 certificate is mandatory and that it has to have all the conditions that are set out. Now, one small error leads to many. And what does the code do? It sets aside 62 and then relies on two maxims to say that we have to make things necessary. And this is where I'm going to come to the Shafi Mohammed part. And what I told you about how, having set aside Shafi Mohammed, Arjun Panditrao literally comes square and fair back to the situation that Shafi Mohammed had set out. Now, what did Shafi Mohammed say? That when it is a third-party document, you can still rely on 63 and 65 process. What would 63 and 65 have entailed there? It would have meant that you had to comply with a notice to produce first before you rely on a secondary evidence. Without issuing the notice to produce to the party who will have the original, you cannot rely on the secondary evidence. All the other provisions in 62, 63 and 65 come up later. The second thing that Shafi Mohammed also said was that discretion about setting aside the certificate, etc., is left with the court. Now, what does Arjun Panditrao say using these two maxims, which is the law does not demand the impossible, and when there is a disability that makes it impossible to obey the law, the alleged disobedience of the law is excused. Aren't these two maxims literally the same grounds on which Shafi Mohammed said that these exceptions should be made? The court uses these two maxims to say, therefore, we are allowing for all these other exceptions. But it could have just as well have applied the same maxims to support Shafi Mohammed, which is what it doesn't do. Curiously, what more does Arjun Panditrao do? It says that in CPC as well as in CRPC, you have provisions for asking for production of documents. Therefore, under these provisions, you are still entitled to call for a document which is in the custody of another person. Now, again, the fallacy that the code does is it is not talking about the original of the electronic record when it asks you to rely on section 165 of the Evidence Act or order, I am now 16 of CPC or section 91 of CRPC. What it asks you to do is to use all of these to call upon the concerned person to give the certificate under section 65B. Herein lies the really fundamental error in Arjun Panditrao, because each of these sections, when you read about it, it talks about production of a document in the custody of another. It doesn't talk about issuance of a document. And therefore, there is no question of reliance on any of these sections to help you with respect to a 65B certificate. You can rely on all of these to ask the original to be produced, or in the alternative where the person refuses to produce, to rely on the secondary evidence. Again, I pause here to point out, how is it any different from what Shafi Mohammed said? What was so difficult for a 3-judge bench to affirm what was stated by a 2-judge bench? Instead of doing that, On one hand, they overrule it and bring it right back to square one to say, oh, you can of course issue file an application before the court, asking the court to seek production of this document from the concerned person. And what is the document that is to be produced? The certificate under section 65B. So what Shafi Mohammed said was, you can apply to the court and ask for production of the document, which is the original, failing which you can rely on the secondary evidence. That is the rule we've been following, tried and tested over decades, right? Instead, here, this is what is substituted. And according to me, this interpretation of each of the sections that the Supreme Court relies on in civil and criminal cases is completely fallacious. Finally, when should you produce this document? Now, from Anwar to Shafi Mohammed, the courts have been striving so hard to ensure that electronic evidence, as the best evidence, as the Supreme Court itself decided, is not kept out. And therefore, they put in these judgments to say that it is a curable defect and it can be produced at any time. Now, this court does not really overrule Sonu versus State of Haryana or the other judgments which came thereafter. The clarification it gives, which was completely uncalled for, and according to me, again, a misinterpretation of the provisions, is this. It says that in civil cases, you have to produce the certificate at the time of giving evidence. And it clarifies and upholds Sonu, etc., to say that, however, if the certificate is defective or there is a problem, it can be cured. But it has now put a cap, which was not there earlier. The cap is that you have to produce the certificate before trial is concluded. And when it comes to criminal cases, and this is where the problem is aggravated, because it says on one hand, and this is a clarification I hope is well noted, because there is a clear possibility of mistakes being made. You know, in early decisions, there were a lot of cases which were decided saying that the certificate has to be submitted along with the charge sheet. It held that at the time when the electronic record is seized, the certificate should also be taken. And if it is not submitted along with the charge sheet, the electronic records were being thrown out. Now, this was modified because of various judgments which came subsequently, including Ramajayam and Sonu was a State of Haryana, and the recent Ravindra Desai, etc. But now this court says that the electronic records, and that's why I'm saying, please note, it does not say the certificate. It says the electronic records have to be given at the time when the charge sheet itself is filed. Because if you do not give it at that point of time, then you're actually causing harm or prejudice to the accused. Leaving all this aside, as a defense lawyer, I'm really thankful for this clarification from the Supreme Court on this, because I have seen in so many cases that, you know, the prosecution uses this one, you know, exception that is always there, which is to say that, oh, but, you know, it was an error on the part of the prosecution that it got missed out. And therefore, the best evidence should not be kept out. And therefore, we should be allowed to give this evidence. Now, when you look at those kind of options, it actually causes a lot of harm when these kind of documents are given much later. So to that extent, one can say that it is better. But the problem that arises is in terms of not giving clarity, in terms of what is, according to the court, is the time frame before which the certificate is to be given. So it tries to explain it in its convoluted process by saying that the certificate may be given at the time of charge sheet or an evidence, especially where it is by the accused. Because obviously when an accused is relying on an electronic record, that is not going to form part of the charge sheet. Now here again, please go back to 65B4 and read the first part. The first part, the legislative intent, is very clear. There was no reason to complicate it in terms of civil, criminal, etc. Because the legislative intent very clearly says that you have to give this certificate at the time of relying on the electronic record in evidence. All the other judgments of the Supreme Court clearly elucidated that in the event you were not able to give, you can cure the defect. It did not need any further clarification. But in the process of giving clarifications, it has confused it more. So firstly, you have a situation where you have to give the certificate at the stage of evidence in civil cases, at the stage of charge sheet in criminal cases. You may be allowed to give the certificate later through permission of court. Again, nothing different from Shafi Muhammad. You can apply to the court for the certificate to be issued by a third party, and the court can issue that, send a summons to the third party to produce the document. And what is the document which the Supreme Court says it can produce? It is the Section 65B4 certificate, which according to me is a completely fallacious interpretation of all the provisions which pertain to production of document. The law is very clear. In the Arjun Panditrao case itself, they record that you cannot compel a person to issue a document. You can't even compel a person to produce a document in many instances. And the kind of findings that are there with respect to issuance of proclamation and warrant, etc., are going to play havoc, with legal proceedings. And I suspect that a lot of people are going to be unduly harassed because of these, because the way a trial court will look at it is the Supreme Court is given the mandate to issue a proclamation. The Supreme Court has given the mandate to issue a warrant. So why shouldn't we? Instead of the much simpler provision, which was already there and affirmed in Navjot Sandhu and in a way brought back through a backdoor in Shafi Muhammad, which is to say, issue the notice to produce to the persons who had the original. If they don't produce the original, then you can rely on the secondary evidence. This is where we stand in terms of Arjun Panditrao. Finally, it goes beyond its brief in terms of all of these and also lays down, in fact, it's very interesting. We talked about Anwar versus Bashir and about how though the person who pronounced the judgment in Anwar versus Bashir was part of Tommaso Bruno already held that it doesn't have to be treated as a code in itself, Section 65A and B. Now here is a case where in the judgment itself, after holding that a certificate is mandatory and whatever it is, even if it is only to the best of your knowledge or belief, you have to give it. And on this ground, definitely the court has correctly interpreted it, which is that it is knowledge or belief and not knowledge and belief. Again, no major discussion in it, meaning no discussion at all in it, but the conclusion definitely is right and valid, because you can't say both knowledge as well as belief. So that is correctly held. But having said all this, in this very judgment itself, they violate their own rule by saying that in this case, since the respondent had repeatedly asked for the certificate and were not given this, in this case, we are allowing for the documents to be relied on. So the confusion that is bound to arise is, who is the person who is supposed to exercise this discretion? Is this discretion therefore, because the Supreme Court did this clarification in its own judgment, where it held 65B4 to be mandatory, can it therefore be held that trial courts can also exercise their discretion to do away with the certificate? If the answer is yes, again my query here would be, then how is it any different from Shafi Muhammad? Right? Isn't that exactly what Shafi Muhammad said? So what exactly did the Supreme Court do with its decision of setting aside all these judgments and then reiterating or affirming exactly the same things in its own judgment in a much more confusing fashion? Now, finally, one, I had raised this query, but let me clarify it here also. How should the certificate be given? So the certificate has to be given in a certificate form. This is to certify that kind of thing. It doesn't have to be in an affidavit format. A lot of people have asked me this question, therefore I'm clarifying it. When you're doing the certificate, just remember this one fundamental first principle rule. When we all started practice and we would want to rely on a what would we do? We always would write down these questions: who, what, where, when, why, how, right? So write down the same questions. Forget about this prefix electronic. Just write down these questions and then fill in the factual details to these questions first. The second step is take it the way I just explained it to you all, because it may seem like a very confusing process. The assume, in fact, I have always been giving this cautionary note. If you listen to every single session of mine, if you read every article of mine, you will see that whilst I have done the analysis of all these judgments, I have always held strong saying, until specifically and categorically proven otherwise, always please follow Anwar versus Bashir and prove all six, because then you're safer. And I can tell you that I breathe easy today because I have always followed this in whichever case. And if anybody asks me also, I have advised them to follow this. So go back to Anwar versus Bashir. One of the things the court did was it tried to simplify the 6 conditions that you have to follow. And it has told you exactly what you need to cover in your certificate. So take those 6 and write it down first as is, and then look at your factual matrix and then prepare your certificate. When you do your background homework, then you will realize that the certificate is not an impossibility. It is just a difficult process. And keep in mind what I told you, those pointers, that one, you just have to give it to the best of your knowledge or belief. You just have to show that that computer resource was in the custody of the owner, right? And you have to explain whether in each document, you have to explain whether you're giving it as the person who's responsible for the device or the activity. Once you apply all these rules, you will realize that the certificate is not as complicated as it would seem. The Supreme Court finally ends off with a couple of things. One, it asks the legislature to review the process of reliance on electronic records. But the majority judgment, that is what is given by all three, the concurrent judgment, does not go into review of the provision itself. That is done in the additional opinion of Justice Ramasubramanian. But in the concurrent judgment, they ask the legislature to follow the draft rules formulated in the Chief Justice's conclave of 2016, if I'm not mistaken, and also point out to the necessity for formulation of rules under 67C, which is for retention of documents. And here, this is where the most important point comes up. Until such rules are framed, the court frames these rules. But having gone on an aside beyond Arjun Panditrao's reference, it restricts it to ISPs instead of intermediaries. If it really wanted to help, and I feel it was a very important addition, it would have been a lot more important if it had given this for all intermediaries and not just internet service providers, and that somehow unfortunately has been missed. I know I have taken a very long time, and I'm really grateful for the kind of attention that all of you have given for nearly 1.5 hours. Thank you all, and I hope that this analysis has helped you in relying on electronic records in your cases or in interpreting them. Please, I would like to by saying, please do not eschew technology. Do not think, oh my God, this is all too complicated. Let's just do away with this electronic records. Let's just go back to our good old paper documents, okay? Because you can't do that going forward. Whatever kind of case you're dealing with, you cannot shy away from electronic records. So just find the path of least resistance and you may actually realize that it is quite easy. Thank you all.
Thank you, ma'am. First of all, there are some questions in the chat box, ma'am. First of all, we can answer that question.
Sure, please. Please, will you be posing the questions to me, or do you want me to go through this?
Mr. Tangachan, you please read.
Yes.
Altogether 28 questions.
And before we start, I'm really grateful to Justice P.N. Prakash, who was the author of the Ramajayan Judgement, who is also present here. So thank you so much for taking time out to be present with us.
And Tangachan, please unmute.
Yes. I unmuted.
The JR computer iPad, that is the
No.
Not name.
Let me read some questions
Yes.
in the chat box. Okay. Yes, there is one question from Bhupender. Dear it will help if during the course of the webinar you could throw some light on the possible instance of device not being in the control, but its output being possession of a party.
I think I had already explained, because it is where the output is being taken from. So when you say output, I would rather use the electronic record. A copy of what you probably mean is like the email, where the device from which the email was generated is not in your control, but you are the recipient of the email. Like I told you, the device from where you're taking the copy is what matters. So you can treat it as such and still give the certificate to that effect. And one most important thing I forgot to add in the summation, I did mention it earlier in the session. Remember, ultimately, see, we are doing this lengthy and complicated analysis actually just for the first step in proving of the electronic record, only for it to be admitted in evidence. After that, you still have to prove the truth of the contents. You still have to prove the that what is stated, as you would with an original, you still have to prove your case. So it is not enough to just think that once the 65B certificate is given and once the document is marked as exhibit, everything in it is also proven. So please do not assume that.
Yes. There is one more question from Bhupender. The position on the stage of producing 65B certificate in criminal and civil trials in the light of the Arjun Panditrao's case.
I think I have clarified that also.
Yes. Then.
So if I'm just quickly going down, may I also just read it myself and move forward?
Okay.
So it says, is this judgment a sign for the legislature to intervene? Well, yes. I would say that not just this judgment. When the section was drafted, it was already a sign for the legislature to redo it. Because firstly, we have to remember just a little bit of the background. The draft was prepared in 1909. The civil UK law from which the provision is drawn was repealed way before that. And the criminal provision was also repealed by UK in 1999. But in 2000, this act was passed. At least at that point of time, somebody must have woken up to say, but they've already repealed, maybe we should relook it. 2008, we got our amendments. At least then they should have relooked it. I can just tell you this. I think the legislature was not convinced enough with the complications that it faced from 2000 to 2014. After Anwar versus Bashir, the bells have been tolling saying, please relook and change the law. And if they did not answer the bells, then I think the alarm bells that Arjun Panditrao is now giving us is definitely a ground for us to relook the provisions. And that is, and not just the confusion and complication in the concurrent judgment. In addition to that, Justice Ramasubramanian clearly says, please review and give us, it is now time for the legislature to intervene. So I would say, yes, definitely. And I can also tell you in last year, I was part of a committee and we have given a report. I am a strong proponent for absolute strike down of 65A and B. We really did not need that. The definition of document is all encompassing. The two of the provisions, at least in terms of 60, 63 and 65, clearly cover electronic records because it's a mechanical reproduction, if not anything else, right? And when you talk about a mechanical reproduction, unlike a paper document, in electronic trails, you can much more easily find the modifications or tampering a lot more easily than in a paper document. Therefore, we really did not need 65A and B. Because if you try to repair something which is already defective, you're just going to get a more confusing issue, just how Arjun Panditrao has landed us. Then several contradictions in this judgment on issues such as the stage at which the certificate ought to be produced. I will give a very simple answer on this. Forget about what the judgment says. What is it that you would want to do? Now you know that the certificate is mandatory. Doesn't it help you that you give it at the earliest point of time? Because let me tell you, some of the funniest certificates I've come across, it will say that the computer is working fine today. You know, when the certificate is being given at the time of trial, you know, and nothing has happened to harm the computer. How does it matter? The certificate is supposed to mention about from the time the document was created to the time the copy was made, the computer was working fine. So you will not make these kind of obvious mistakes if you give the certificate on time. Of course, there will be a problem in terms of whether the certificate, you know, whether the person who's giving the certificate will still be available with your company to give evidence, because the attrition rates are so high in companies now. Between the time of a case to the trial itself, the parties may not be available. Many people would have changed. So you can worry about that later. But for now, I would say that the certificate, as a matter of best practice, please ensure that when you're handing over an electronic record, you do it along with the certificate. Otherwise, I've already clarified the various complicated processes that the Supreme Court has set out in the judgment. And you're right that there are indeed contradictions. As far as the next question is concerned, in terms of Shafi Mohammed and no bar for the investigating agency to seize the electronic evidence and they can produce it, you're right. As I already told you, there are two reasons. One is based on the device and the other is based on the activity. And therefore, this problem with respect to criminal cases can be overcome. Whether certified copy of call detailed report given by Telecom Authority can be said to be in compliance of Section 65B. Now, when you look at the Arjun Panditrao case itself, when these electronic records were given, it was given under a certificate. If you read the first part of the judgment, it even reproduces the certificate. But however, the respondents also have treated it as if no 65B certificate has been given. And the Supreme Court also does not interpret that certificate to be on par with the 65B4 certificate. There is also no clarification on why did it not treat it so. If it did not intend to treat it so, there is also no clarification on what was the purpose then of reproducing that certificate in that judgment. So I would say that a certified copy of CDR is not sufficient. It has to be a 65B4 certificate complying with those 6 provisions. Because if you look at a certified copy, all that it will give is, it will give you a printout of the CDR and then just a chapa saying true copy. That doesn't comply with those 6 conditions under 65B. Therefore, I would square and fair say that it doesn't amount to a 65B4 certificate. In case of developed and transferred compact disk, who is authorized to issue a certificate? I think I've already answered that. Again, device or the activity. Whoever is preparing that compact disk can also give the certificate. And the next question, the citation and link for Nappinai man's article.
Yes,
fact, I had already shared all of it in the beginning, yes, so that it would be.
And again I shared it. Again I shared it.
Oh, sorry.
I shared it again.
Excellent, excellent. Thank you so much on that. So then, moving forward, in family matters, how can we give certificates saying kept in course of business? Very important question. Now, 2 things come up with various judgments which have not been overruled in Arjun Panditrao, so thankfully so. One is, in a family court matter, strict rules of evidence do not apply. One could say this applies pari passu to arbitration matters and all that also, right? Again, the problem is always going to be for us having been burnt once by following Navjot Sandhu and then being told, oh, sorry, you followed a Supreme Court judgment, which was so wrong for you to do. We don't want to be told tomorrow, sorry, but you may think that strict rules of evidence don't apply, but you still needed the certificate. So again, I'll give this pinch of salt caution that just give the certificate. It's so much easier for you to give it rather than avoid it, okay? But in a family court matter, and in fact, one of the earliest cases that clarified this in the course of business was actually a consumer court matter. All the judgments clarifying this, you will find it in my book itself, Technology Laws Decoded, and in all the subsequent articles, etc. But briefly, they interpreted to say that ordinary course of business is not a commercial activity. It merely means in the ordinary usage of the computer. So therefore, when you look at the practical interpretations, you will realize that family court or any other court, you will not have any difficulty in terms of relying on the document. Certificate is not necessary before family court. Please go through. I'm very grateful to Haridas. He has reiterated what I told you now. I think that's effectively the end of the questions. If anyone else has anything, I'm happy to stay on call till 1:30.
Yes.
So please do let me know.
Please.
Okay, so there is one question that has come up about copying to a pen drive. In fact, I used the data theft example a lot. I did not say copying into what medium, because copying into what medium is irrelevant. Whether you're copying it into a document or for printout or a pen drive, whatever, it doesn't matter. What matters is that it is a copy that you're relying on. So now, if your question was that where an employee copies the document onto a pen drive and how do we prove the data theft, that's a different issue and doesn't fall into the proving of the electronic record part. Reach out to me, I'll be happy to help you on it. But to give you a brief indication on that, follow the trail. About cyber crime, forget about electronic evidence, remove the cyber, remove the electronic. What would you do otherwise? You would follow the trail. You will ensure that every single link to the chain of custody will be proven, and you will set out the facts, details, documents, and the proof for each stage of that chain. Do the same thing, you will be able to establish your case.
Okay. Dear Ajit, any question from you?
No. Informative.
Okay.
Mr. Haridas from Attapalam.
Yes.
Raised.
Hari, you can unmute yourself. Haridas,
unmute.
Mr. PP Bashir.
Hello.
Yes, Haridas, please, you can ask. Haridas, you can ask. Hello.
Yes. And I just put a citation here.
Not audible, Haridas.
Hello.
Yes. Hello.
Sir, there was a question. No, I not my question. One Sadhana Kumari put a question whether it is applicable to family court or not. I just put a citation. The Kerala High Court is clarified in 2019.
Yes.
That is by division bench headed by Justice Abdul Rahman. That is with the interpretation of Section 14 of the Family Court Act.
Correct. That it is the
Section 14 of the Family Code starts with that notwithstanding contained in any other provisions in the Evidence Act. That is not about family. That's even though the fact that 65B is necessary, the Kerala High Court just clarified that it is not necessary at all in family court. I just put a citation, that's all.
Okay.
Yes.
Hello?
Yes.
There are two new questions that have been put up. One is that a CD was given by the video shop, but they refused to give the certificate. As has been mentioned in Arjun Panditrao, you can apply to the court to direct them to appeal them. before the court and to give the certificate. My suggestion is also, for good measure, issue the notice to produce and strictly rely on it, irrespective of whether this person comes or not, because there is no need to go into proclamation and warrant and whatnot for that. Because if the certificate is not then on par, also then your document will get struck down, right? You can't, one insist that they have, you can't compel a person to give the certificate. You can't compel the person to give the certificate in the way you want it, right? Therefore, the notice to produce and then seeking permission from court may be the better option. But effectively, if you're following Arjun Panditrao to the T, what it says is that you have to file an application before the court, ask the person to come and produce the certificate before the court. And yes, chain of custody always has to the point where you have to prove. No, if you're trying to prove theft, obviously it's not enough for you to show that an article has left your custody. You also have to show that it has been taken into the custody of somebody else. Yes, sir. Over to you, Mr. Shankar.
Yes, yes. One more.
Okay, madam. Thank you very much.
Yes, one more. Ma'am, our friend Vijay from Chennai is there with us. Do you know Mr. Vijay sir from Chennai? Sir, can you hear me, sir?
One sec.
Hello. Yes, I think he is not audible.
Yeah, hello.
Hello. Yes.
Yeah, sorry, thank you. Hi, Nappinai, how are you?
Very good, sir. I can't see you much because there is a light behind you.
Light issue.
Yes.
I suppose.
So nice to see you after so long.
I delighted to see you after so many years. After the meeting and training program we had together conducted by Geeta Ravindra about mediation.
On mediation.
Yeah, long ago with Mr. Vipul Sriram.
Yes.
And after that, we never had a chance to interact or meet each other. But I just wanted to attend this because of Mr. Tangachan, our common friend, who sent the notice about today's talk. And I must compliment on the mastery of the subject and the clarity with which you have spoken, which are, of course, only to be expected from you.
Thank you, sir.
Thank you, sir. Thank you.
No, it was a pleasure. Pleasure is mine. Thank you. Nice meeting you. Thank you.
Okay. Jeta, can you hear me? Vijaykumar.
ശശിയേട്ടന് unmute ചെയ്യും.
He's already muted. Shashi, would you hear me?
Okay.
Yes. Yes.
Excellent class. Thank you very much.
Not audible, Shashi.
Power boy.
Yeah.
Vijaykumar.
I think he is not seen now. Shashindran, BPS?
Yes.
Yes.
Can I hear?
Yes.
It's an excellent class. Madam, as you said earlier, it is our Onam days. It was just by taking a journey from Anwar to Arjun, you have given a tasty feast. As far as Onam is concerned, definitely it is one of the most important part in Onam. And you have given it in a very tasty manner. And thank you for giving such an excellent class.
MCR.
Vijaykumar left.
He's in left.
Yes. Very informative about information technology. She had 65A as well as B, and even explained everything. And I think it is very informative to all lawyers who had participated. I think for starting 165 and last 100, at least 100 persons are attending.
Yes.
Okay. Am I
Okay.
Okay, now we can wind up.
Yes.
തങ്കച്ചൻ അങ്ങനെ ജഗത വക്കീലിനെ വിളിക്കാം.
Yes. Jagada, please unmute yourself.
Can I speak?
Yes. Yes, yes.
I am the
Narasim.
yeah. Good afternoon.
Please wait.
I am speaking from the land of Lord Jagannath from Cuttack, Odisha.
Okay.
Happy Onam to all of you.
Okay, thank you.
It has been very recently. I had a case in the High Court where I was fighting for a bail application, where I was advancing that this evidence can't be looked into because there is violation of 65B because the certificates have not been given. I wish I had this session earlier so that I could have even argued better. Thank you so much, but with one reservation, ma'am, that I respectfully beg to disagree so far as your observation is concerned that this judgment has landed us in a quandary. In an appropriate forum, I'll try to put forth my views. Thank you so much. It has been such a pleasure and a learning experience, and my namaskar to all of you. Thank you.
Thank you. Thank you. Advocate Bashir. Advocate Bashir, can you hear me?
Yes, I can hear.
Yes.
Nothing more to say. It is a very excellent class and a very good experience. And I extend my thanks most for the organizers as well as the dear madam. Okay?
Okay, thank you. Then, Vinod, I think we can conclude it now.
Yes.
Then Jagadabai
is available.
For vote of
Okay.
thanks. Yes.
Am I audible?
Yes.
Ma'am, it was a very good critical evaluation of the act, and it was very wonderful session. We are very thankful to you for this session, and I think in the coming era when our law is being completely changed by the authorities and without any discussion, what will be the fate of this act? That I am afraid of.
Yes.
We are expecting so many changes in the criminal as well as civil act, and such modifications are being coming without any discussion.
Yes.
We have debated so much in the earlier time of amendment, but now it's very quite unfortunate to have these much changes. Thank you for the wonderful session, ma'am.
Thank you. One of the good things that's happening today is thanks to technology. Kashmir to Kanyakumari.
Yes.
So I hope that going forward that any kind of changes is inclusive and the South is given equal representation as is the North. So, of course, not to ignore the East and West. I hope all of India are going to participate. And in fact, in the Commercial Courts Act, that was done. Consultations were in each region before it was passed. So things like that are the future of lawmaking, actually. Yes. Thank you all. Thank you all.
Thank you, ma'am.
Thank you, ma'am.
Thank you.
I think we can wind up the session now.
Yes. Thanks.
Okay.
Thank you.
Thank you.
Thank you.